All right, if folks want to put in the chat where you're calling in from, what your business is and where you're calling in from. I'm Riley O'Brien. I'm the Associate Executive Director with OEN. Glad to have you all here. I'm calling in from Southeast Portland. As you can see, my laundry room where I've been working for the last 5 years. Glad to have you all here this morning. This is I'm really excited about this program. We've worked with Parna before, and she puts things into a way that makes it easy for people to digest and understand. And so I'm so excited to be partnering with her on this program this morning. It's Startup Business Essentials, Protecting Your Investment, Legal Considerations for Now and As You Grow. And Parna's with Tonkon Torp. She's got an impressive resume working with folks and advising for trademarks and talking about IP. In fact, Parna, I'm stealing this from your LinkedIn, but the World Trademark Review 1000 named Parna a leading trademark professional. And she's phenomenal at securing and protecting trademark rights and educating content teams on their use. So we are so excited to have her thought leadership with us here this morning. So Parna, I'm going to let you take it away. Before we jump in, Parna said if you have questions, feel free to interrupt her. You can either raise your hand or unmute throughout the session, or if you want to put it into the chat, then I can unmute and ask for those questions for you. So take it away, Parna.
Excellent. Thanks, everyone. I was just trying to quickly read through the chat so I could see where everyone's background and where they're joining from. I'm going to share my screen to start. And then if you all could just give me a thumbs up, if hopefully you can see it. Good. Riley, can you see that?
Yeah, it looks great.
Okay, super. Nice to meet you, everyone. I'm Parna. I'm a partner at Tonkon Torp. As Riley said, my practice is sort of across the board of IP, which is intellectual property, and that covers trademark, copyright, trade secrets. I am not a patent lawyer, so we'll talk just for like a 30 seconds about patents, and that's it. But we can direct you to someone that can help with that if needed. I also do work in the space of privacy, and then, as I like to say, sort of any other weird thing that happens on the internet. So from navigating your social media accounts to sort of advertising to, someone stole my Uber Eats account, things like that, that all sort of falls on my desk. So if you have a question during the presentation, feel free to just chime in. If you want to do the hand raise emoji, that's fine too. If you want to put it in the chat, that's fine too. And Riley will help me make sure that we catch all of those questions. If your question is super specific to your company, I might have to answer generally as opposed to giving you very specific advice, but we can always talk about that offline later. Okay, so we're going to talk about protecting your investment. I'm going to try to keep this as general as possible for all different types of companies, but we'll use some examples that might be specific to some industries. And then I will say that my practice really spans from like one person startup all the way to, international companies that sell worldwide. So I'll try to give you sort of a general answer that falls into the startup community, but sometimes it's good to sort of see how these things shake out for companies of all sizes. Okay, so let's see. So here's what we're going to talk about today, a little bit about contracts, and then the broad category of intellectual property. Trademark, copyright, trade secret is what we'll focus on. We'll also just give you an outline of the difference between those things. And then we'll talk a little bit about advertising claims as well. All right, so contracts, really what they are is relationships that you have with folks that you do business with. And we're talking about contracts to the extent that they can help you protect your intangible property. So the first point is you should always have contracts. I know as a startup, A lot of your um, work is building relationships, meeting people, creating relationships. And I've heard from a lot of folks in the startup space that it feels sort of a little bit stepping over some sort of a line to ask someone for a contract. But actually, it's a very professional and expected to have contracts with people that you do business with. You should not be relying on handshakes, unwritten agreements, or promises, particularly where there is some sort of transaction between you. If it's someone who's a mentor, I think that that's a fine relationship, obviously not to have a contract with them. But if it's another company or someone who you're collaborating with, someone who you're hiring to do a job for you, you should always have contracts with those people. This should go without saying, but you should definitely read your contracts before you sign them. Lots of situations where you're hiring a vendor, you may not have a lot of leverage to negotiate the terms of a contract, but that still doesn't mean that you should just sign it without knowing what's in it. You always want to know what you're agreeing to, even if you don't have the ability or the leverage to negotiate on the terms. You should be sort of going in with your eyes wide open of what the terms are, so you know how to modify your behavior so to avoid any negative impacts from the contract that you're entering into. As I said before, it's responsible. It should be expected. If you propose to someone to enter into a contract with them, like a non-disclosure agreement is a very common type of contract in the startup phase, where you're sharing sort of secret information or proprietary information with another company, and you don't want them to be able to share it with others. If someone sort of scoffs at requesting that they enter into that kind of an agreement, that should be a red flag to you that maybe you want to do business with someone else. Having an agreement, having your relationship memorialized in writing really just provides you with certainty. You know how things are going to go, and it protects you so that there are terms on both sides that can protect both companies depending on what the relationship is that you're entering into. I skipped over that one. So non-disclosure agreements, that's a really common type of contract. As I said, that protects, essentially it's a confidentiality agreement. The other party is agreeing to keep information confidential that you give them. And these can be one-way agreements so that one party is restricted. That means one party is giving information and the other party is receiving it, and the receiving party is obligated to keep it confidential. They can also be mutual, which means that both parties are giving confidential information to each other and both parties are restricted. Those are really common, and most often, like if you're talking about someone that you're going to be hiring as a vendor, both parties are likely to have confidential information that you're sharing with each other. Later, we're going to talk a little bit about trade secrets, and trade secrets can only be protected through these types of agreements and other behaviors. So they're very important to protect things that can't otherwise be protected through the law. In a contract, you really want to understand what you're giving away and the purpose of it, right? So what information are you passing along and the purpose for passing along that information? And that will define like the restrictions that you put on it. You may also enter into a joint development agreement or a collaboration agreement with another company. And if you're entering into that type of an agreement, you want to know who owns what are you bringing to the table, what are you creating together, and what are you taking away? What are the restrictions on what you can do with pre-existing content or information or knowledge that you're bringing to the table? And what are the restrictions on what you can do with something that you're creating together? Who's responsible for doing what in that relationship? Outlining the scope of not just what you're bringing, but what your work is that you're going to be doing, and who's responsible for each of the piece of the collaboration or development. And then finally, these are not all the topics you're going to cover in an agreement, but they're some of the ones that focus specifically on protecting your intellectual property. Exclusivity is another topic. And that's, again, if you're entering into a relationship with another party, are they going to be able to enter into the same type of relationship with another party or with a competitor? Are they going to be doing the same type of business with lots of different companies in your industry or just with you? And often this is going to depend on who the other party is, but if they are doing business with others in the same industry, you might want to put tighter restrictions on what they can do with your intellectual property. Or if you're a big enough customer or a big enough, the relationship is big enough, you may want to ask for some level of exclusivity. And that can be on all different areas. It can be geographic exclusivity, it can be industry, it can be just be your specific product. If it's like a packaging relationship, it might be they're not going to sell that same bottle or that same box to another company, but they can certainly work with others in that industry. So it just depends on the scope of what you're trying to protect. Okay, any questions about contracts? All right, so intellectual property, let's dive into this topic. Intellectual property covers a broad array of rights in intangible creations. So I would say when I first got into intellectual property, which was 20 years ago, it was a lot more novel than it is now, right? Like companies still had a lot of assets in real estate, obviously employees, they had inventory, a large piece of the value of a company, you could actually sort of see it or touch it. It was tangible goods or tangible property that they owned. Now, really a short time later, the vast majority of the value in companies is in intellectual property. And so it's just become more and more important. So there's several different types of rights and assets that fall into this category of intellectual property. The first one is trademarks. Trademarks are names, brands, logos, or product shapes that protect a product or a service. Essentially, they're identifiers. They're source identifiers that if you see the word or you see this image, you immediately know the source of that product or service. So the easiest and most local example of this is Nike. If you see the swoosh on any product or on a storefront or on anything, you know immediately that that comes from Nike. And that gives you a whole bunch of information that you've obtained as a consumer about what you can expect, right? Because you know all this stuff about the company just from looking at the swoosh. That's the value of a trademark, is all of that consumer information that consumers associate immediately upon seeing it. And it can be a slogan like "Just Do It." It can be an image like the swoosh, or it can be the company name like Nike. It can also be a product shape or a packaging shape. So like the Coca-Cola bottle, the glass bottle, that's a shape that is protected by Coca-Cola. Those are a little bit of a harder trademark to obtain, but that's also a type of trademark. The next type of intellectual, and we're going to go into detail about most of these. So the next type of intellectual property is copyrights, and copyrights protect expressive works. So it's a expressive work that's put into a tangible medium. So you can protect a writing if it's written down, right? If it's not just an idea, but put into a written form, artwork, choreography, music composition, images, software, to the extent it's written, anything that's put into a tangible medium. Patents protect non-obvious, original, and useful inventions. And so generally, these are inventions that are used in any sort of manufacturing or creation. there are some processes, scientific processes, chemical processes that can be protected by patents. I'm not going to go into a lot of detail about patents. It may apply to some of you. It's just outside of my area of expertise, but it's one of the big portions of the IP landscape. And most patent lawyers also have to have a science background. So if you're working with someone that drafts patents, they will also have like an electrical engineering background or mechanical engineering background, whatever specialty is needed for your particular invention. Trade secrets are also a type of intellectual property. Trade secrets are not registered anywhere. You don't file them with any government entity. What makes a trade secret protected is that it's commercially valuable and that you keep it secret. So it's essentially created by your actions in keeping the information secret. These are things that can't otherwise be protected by the intellectual property laws, like recipes can't be protected by copyright or by any of the other intellectual property laws. So lots of companies keep recipes protected by keeping them secret. Formulas, lists of customer information, sort of internal know-how, things like that are all protected by how you treat the information. Okay, so why does it matter? I talked about this a little bit already. Intellectual property is one of the most valuable business assets. I would say probably the most valuable business assets nowadays. It builds brand awareness and loyalty to your brand. It establishes protectable legal interests. It has value. It has monetary value. It can be sold, licensed, or leveraged. It gives you a competitive edge and obviously drives innovation. In the startup space, to the extent you're considering your growth trajectory and what an exit might look like, both investors as well as if you're considering growing your company and then selling it, along the way, your investors are going to expect that you're taking actions to protect your intellectual property because it does create value and goodwill, as well as gives you that competitive edge, as I mentioned, and prevents others from essentially doing the same thing using the intellectual property that you're creating. Okay, we're going to dive into trademarks. Just leave a second if anyone has any questions so far. Okay, so what are trademarks? They can be a word, a logo, a tagline. They can be color. So if you think of like the cell phone companies, they all have like Verizon has red. They use that on their commercials for their map. And other companies, I think, I used to be able to rattle them all off, but other companies have different colors. I think T-Mobile uses pink, and they're all sort of known for the color that they associate with their brand. You can also have sounds. So the NBC, the chime that NBC uses, that's a trademark. You can have a scent. So the smell of Play-Doh, that's a trademark. And then a package design, a product design, or a store design. So like the design of an Apple store. If you go into an Apple store anywhere in the world, they all look the same and they have a trademark on that store design. Those types of trademarks, the packaging, the product, and the store design, those are sort of a collection of elements, and that's called a trade dress. That's another name for that type of trademark protection. And it has to be non-functional. So you can't protect like the fact that a store has 4 walls, but you can protect the fact that those walls are made of glass, right? Plus all of the other elements that go into what the Apple Store looks like. So one thing that often is confused with trademarks is that just because you have the business name, your business name might also be your trademark, but you do not automatically get trademark rights just because you have registered the name of your business. So it's a different registration process. It's a different type of use. If you're using your business name like with the Inc. or the LLC, that's not considered trademark use. You would need to use it as a brand, so without the business designation. You also don't automatically get trademark rights just because you have a domain name. And having a trademark does not automatically entitle you to the domain name. So those things are not interchangeable. There's interaction between all of them, and there's some situations where you may be able to pursue it, or you may be able to establish trademark rights from a business name or a domain name, but it's not automatic because they're slightly different. Okay. So when you are coming up with your trademark, or when you are determining whether you can protect your name as a trademark, the first step that you're going to do is clearance searching. Searching is really crucial at the beginning of your the process in terms of how strong your trademark is, whether you can protect it, and whether there's any risks associated with using the name or the image that you want to use as your trademark. No trademark search is going to find everything that's out there. We can find a lot more now because we can search online, and that didn't used to be the case, but searching can give you a really good idea of whether there are other people out there using marks that might be an issue. So in the trademark analysis, what you're looking for is not just, okay, is there someone using the identical mark for the identical product or service, right? If I have a trademark that I'm using for, an ice cream store, if someone is using the same exact trademark for a restaurant, that still may be an issue, even though it's not identical to what the services are that you're offering. Someone may also have the same trademark that's spelled a little bit differently, or it has another word attached to it. All of those situations may not be identical, but they still may be a trademark issue, because the standard for trademarks in looking at whether or not there's a problem or an infringement with somebody else's trademark is likelihood of confusion. So it's not identical, but is a consumer likely to think that there's some relation between the two companies? So when we're doing searching, we're not just searching for identical marks, but you want to search for things that are similar, spelling variations, sound alikes, things like that. And you want to be broader than just the exact mark that the exact services or products that you're selling. The benefit of doing searching at the front is that it can avoid expensive headaches later, so disputes with other people that might be using a similar mark. You can't rely solely on searching online. You can search on Google or another search engine. You can search on the USPTO. You can search on business data, like business name databases. But you want to make sure that you're searching broadly enough that you're going to catch something out there. Lots of marketing agencies will come up with names and logos for you. Their job is generally the creative portion of it. Most of them do not do trademark searching. Most of their contracts with you are going to say that they're not responsible for trademark searching, and that it's your responsibility to pursue trademark searching. You should, obviously I'm biased, but in my view, you should have a lawyer do searching for you, or at least make sure you're searching broadly enough that you're looking, again, beyond just the identical mark and the identical goods or services. When you use services like LegalZoom, they will conduct the search for you. My understanding is they're not going to be giving you advice on what the results are. So they will conduct a search and then send the results to you, and it's up to you to review the results. So the reason, again, with my bias, is to be skeptical, because they're not going to give you, in my experience, are not going to give you advice on what the search results mean. And that's really the crucial component of trademark searching. I'm sort of hammering on this because what tends to happen is that, especially with startups, people will come up with a name that they just really love and they get really like committed to it, or it has like a really deep meaning for them. And it's very difficult to address disputes later on once you've like committed all of your investment and all of your time and energy into building a brand, and then you find out like a year in that someone sends you a cease and desist letter. And it can be also sort of troubling at the very start to have to change your name, but the sooner that you know, the better. And often if you can avoid or at least know going in what the risks are, that can be helpful in directing, the decisions that you make in terms of investing in the marketing and the name and all of that. Okay. So once you begin using a trademark, you get the right to continue to use it so long as, or I'll say with respect to people who come after you. So if you start using a trademark first and someone starts using it after you, you do not have to stop using it because you were first in line. You may have to stop using it if there was somebody before you. You also get to prevent later users from using confusingly similar marks. For someone that comes later than you that is infringing your trademark, you have the right to sue for infringement, even without a registration. And the territory of your rights is the area in which you are using the trademark. You also get to use that little TM symbol to notify people that you consider something to be your trademark. And you can use that TM symbol even without a registration. So as soon as you start using a trademark, you are allowed to use that. If you want to pursue trademark registration, you get additional rights in addition to those that I just listed. So once you have a federal trademark registration, your rights are nationwide. So even if you haven't sold products in Connecticut, if you have a federal trademark registration, you could stop somebody in Connecticut that came after you from using the same trademark. You get to use the little circle R once you have a registration. And the trademark statute gives you additional potential remedies in a dispute with someone. So additional potential monetary damages, including potentially an award of your attorney's fees if you have a registration. If you have a registration, the trademark office will also potentially refuse applications that are filed after your registration. So if you have a registration and then somebody else files a similar trademark after you, the trademark office examiners may decline to register the person that came after you because they don't want there to be confusingly similar trademarks on the trademark register either. If you get in a dispute, your trademark registration is also evidence of your ownership of the trademark. So in court, you just present your trademark certificate, and then that's proof that you own the trademark. If you don't have a registration, in order to prove ownership, you have to put a bunch of evidence into the record. So here's evidence of all my sales, here's evidence of all my marketing, here's evidence of invoices where I sold stuff to customers. You have to try to prove that you own it.
Oh, no, I'm just listening to a legal.
And then another benefit of trademark registration is that after 5 years of registration, your mark can become incontestable, which means that the bases on which someone else could challenge your mark are limited. If you sell products, another benefit of registration is some customs protection. So you can register your trademark with Customs and Border Protection, and they will stop counterfeit goods from being imported. And there's also international treaties that exist. When you have a trademark registration in the US, it just protects you in the US, but there are international treaties that help make it more efficient and less expensive to file in other countries if you decide that you want to file your trademark in other countries. Okay, I usually get a bunch of questions on trademarks, but nothing so far. Does anybody have any questions on trademark searching or trademark filing or anything like that? No, okay. We also have time at the end if something pops into your head. So I just wanted to talk a bit about advertising and labeling for those of you who sell products. Some of these bullet points are specific to food and beverage because we do a lot of work with food and beverage companies at OEN. So there's advertising, sort of the restrictions or the best practices on advertising claims. So these are things that you say about your product or service, whether it's printed on packaging, whether it's on your website, whether it's any sort of marketing that you do. So there are specific rules and regulations that apply to certain products. Those are, in the Code of Federal Regulations. They're in agency rules. Those I've listed the ones, for example, that apply in the food and beverage space. So nutritional panel, ingredients, allergens, things like that. You can also make, there are health and wellness claims or other types of claims about what your product does or the benefits. Some of those are regulated and some of those are unregulated. So one example is like the use of the word natural. That's not a regulated word. Lots of people use it. You can, separate from the regulations, there are just general advertising rules that are basically that your advertisements cannot be false or misleading. So even if you're using a word like natural or another word that's not specifically regulated, you still have to make sure that what you're saying is not false or misleading, because you can still get into trouble with either consumers or like attorneys general if you're saying something about your product or service that is arguably false or misleading, even if it's not directly false, if it can lead to a false or misleading impression. This includes like the imagery that you're using on your labels. Those can create false impressions or misleading impressions because people look at the images as providing information. There's a lot of litigation on these topics in California, for example. One example is there was a case in California where it was a dairy product that had a picture of like a cow in a field, and it looked very serene and like, a nice, beautiful scenery. And there was a false advertising lawsuit against that company because those cows were not actually in a field living a serene life. And it gave the impression that the product came from a source that was not accurate as to how the product was actually created. So that's all very food focused, but there's those advertising rules about false and misleading apply to all products and services. So competitors can bring advertising claims for false advertising. That's actually under the trademark statute. Regulators can bring claims, and then also consumers can bring claims. So you just want to make sure that you're aware of any regulations that apply to your product or service, and then also just a general overview that your advertising is not false or misleading. I'll spend just a second talking about social media with regard to advertising. These rules apply also in the social media space. So where we're seeing them come up now very frequently is with reviews. So companies have gotten warning letters or from the FTC, the Federal Trade Commission, about like posting reviews that were not legitimate customer reviews. So creating a program or incentive for people to post reviews that are not entirely accurate, it's not actually the consumer's opinion, that can be considered false and misleading advertising. There's a lot of talk about social media influencers and how they have to notify the public about their involvement with a company. So There's specific rules in the FTC about not just governing influencers themselves, but also governing the liability that companies may have. So if you are hiring other people to do advertising for you, you are responsible for what they say, and they are also responsible for what they say. So the company cannot just sort of put off the responsibility onto someone else that they hire and say, oh, we didn't have any control over them. They were doing what they wanted. You're going to also be held responsible for the actions of folks that you hire if you're going down that road. So there's specific rules to think about with respect to your sort of online advertising that are kind of non-traditional, but the FTC's rules are sort of general enough and broad enough that they can be applied in those circumstances. And they are being applied in those circumstances. In the vast majority of, I would say, I don't want to overstate this, but the FTC is really focused on things that can harm people. So like you may not be in the crosshairs of what the FTC is focused on, but these are all just good habits to get into. And sometimes the FTC will sort of take on an industry as a whole, right? And look at sort of what everybody is doing in a particular industry. So it's just good best practices to be aware of and to keep in mind as you're growing in particular, because as you grow, you may no longer be sort of directly involved in all of these decisions. And so it's something that you just want to keep your eye on. Okay. Advertising questions? Okay. So
Parna, there were a couple of questions about trademarks that came in after you moved on.
Oh, super. Are they in the chat?
They are in the chat. Do you want me to read them out to you?
Yes, that would be great.
Okay. Alan asked, do trademark searches have a fixed or variable cost? What should we expect to pay an attorney for a trademark search?
Excellent question. So the cost is going to depend on the scope of the search. So I can tell you, like, we do like 3 levels of searching. The first one is very quick and narrow. So we call it a knockout search, and that's like identical mark, identical goods. As I said, that's not the scope of infringement analysis, but sometimes if you're like already 100% in on a trademark and you're not going to change it, and we just need to know, can we file for an application? Like, are we going to be able to get it? Then we'll do just a quick and narrow knockout search. I would put that in the range of $500 to $700. The middle of the road search, which I think is the most common, is what I call a preliminary trademark search. We search the trademark office. We search for state trademark registrations because each state has their own trademark registration system that just covers that state. So we do federal, state, and then we do a little bit of searching on the internet. That level of searching will generally come up with any big red flags. It will tell you sort of what are the risks in filing an application and potentially getting a dispute from another party. And that type of search I would put in the range of about probably $1,200, $1,200, $1,200 to maybe $1,500. And there's a range because we could do a search and we could get like 20 hits, or we could do a search and get like 70 hits, right? So we don't really know how much stuff we're going to have to review until we do the search. So that's why there's kind of a range. We try to limit our preliminary searches to about 50 hits at the most. And so we might need to make it really narrow to get down to that 50 hits. So that's kind of the middle of the road. And then the most robust search, it's called a full search. And we order those from a vendor that they have essentially data analysts that just do like trademark searching. And it's all very big computerized searches and it's very robust. We order those from a vendor. The out-of-pocket cost for those to the vendor, I think, is about $1,000 to $1,200. And then our time is going to depend on, again, like how voluminous the results are. But usually I think all in on that full search, I would estimate about $3,000 to $3,500. Sometimes we get those full searches back and they're like 800 hits, and sometimes they're like 4,000 hits. So those can, it really depends on what the trademark is. And as you might be able to guess, the more sort of commonly used the word is, the more voluminous the results are going to be. If it's a completely made up word like Google that nobody's ever heard of before, like probably you're not going to get very many hits on that search. So you have this in trademarks, you have this like, if it's a completely made up word, you probably have an easier go of it from a trademark perspective, but you have way more difficult education of your consumers, right? Because they don't know what it is. So you spend a lot more time marketing. If it's a very common word or a very descriptive, like your dry cleaners and you're calling it, clean clothes, that's going to be, you're going to have also a difficult time with a trademark because you can't really protect words just to describe what you're doing, but your marketing is going to be pretty easy because people are going to know immediately what you're selling to them. So there's sort of a balance there that you're doing. So that's kind of the range for trademark searching. You may get like a flat fee trademark search, and you just want to make sure if you're getting, are they just running the search and giving you the results and leaving it up to you to analyze the results? I think that's, like I said, what kind of the LegalZoom type of companies do. Or are you paying for them to run the search and also to tell you like the pros and cons and the risks? And that's really the valuable part. The last thing I'll say about searching is it would be rare for me to say absolutely yes or absolutely no. Usually I say like low risk, medium risk, high risk, and leave it up to you to make the business decision. And that's because if I said, oh, absolutely, you should not do this, and then you decided to do it anyway, that could be really bad for you later on if there was a claim, like an infringement claim made against you. Generally, we just try to assess like low, medium, or high risk, and then you get to make the decision as to what your like risk tolerance is. All right, Riley,
There's one more question. This is from Ty. I already filled out the USPTO trademark application in February, and that's still pending. Is there something I should do in the meantime? I did not check with a lawyer or attorney yet.
No, I mean, probably not. You probably are fine. The trademark office's current turnaround time for the first step, which is assigning it to an examiner and having them examine it, their average is 8 months from the time that you file it. So between, I think 8 to 12 is pretty realistic. So you should just make sure that you're like checking your spam email in case you get a notification from the PTO, because they're like automated. And so you just want to make sure you don't miss anything, but I wouldn't be too worried, like 8 months, I would start like keeping an eye out for it. But I would be surprised if you got something sooner than 8 months.
Great.
Any other trademark questions?
Anybody have any questions?
Okay. Trademarks is my favorite topic, so I can talk about trademarks all day. All right. We're going to move on to copyright. Let's see. Am I on the right screen? All right. So copyright protects works of authorship that are fixed in any tangible form or medium, and they have to be original. And original does not mean like artistically good or artistically like different. They just have to be original in that they were independently created. They have to be minimally creative. So what that means is if you're trying to file a copyright application for an artwork and it's just like a picture of a square, that's not minimally creative because that's just a square. If it's even something like, I mean, think of like the Olympic logo, like that's just circles. but that could be protected by copyright because it's unique in that there's different colors and that they're overlapping. So just minimally creative and originally created, or independently created. Literary works, pictorial works, graphics, sculpture, choreography, I listed these things earlier. What you cannot protect is ideas. So the idea of doing something a certain way cannot be protected. But if you put your idea into like a manual or a handbook or workshop materials, you can protect the form of like the tangible written out version of it. But that doesn't stop someone from having the same idea and having their own version of that. You can't protect like lists of information. You can't protect systems or methods or processes. For most companies, this is going to be like creative works like that you're doing, like photographs. They might be designs that you're creating. You can protect software code with copyright, so written out software code. Again, there's pros and cons of that. The Copyright Office has the copyright register. If you go to the Library of Congress in DC, that's what is in the Library of Congress, is like everything that was ever subject to copyright. And it's a public record. So for things like software code, you're balancing, like it's in the public record. The Copyright Office has some procedures that are specific to software code that allow you to still get protection, but not put everything in the public record. So it's a combination of like redacting or like different portions of your code. So it's still a benefit, but there's still a little bit of, you're putting it out in the public record. So some people can try to protect code as a trade secret as opposed to with copyright, but those are the options. Copyright ownership, there's authorship and there's ownership. So the author is the person who created it, and the author automatically has ownership, with the exception that it can be transferred in writing. You cannot transfer a copyright verbally. So it has to be transferred in writing. And the other exception is that if you're an employee and you create something in the course and scope of your employment, it immediately belongs to your employer. Many companies have that is automatic in the statute, but many companies, if they hire an employee, they will also put it in the employment agreement, just as like a belt and suspenders approach. And the other reason that it's in a lot of employment agreements is because this is not true for patents. So when you create something that's patentable as an employee, it does not automatically belong to your employer. That's why for most industries like software and engineering, as part of your employment, you sign a inventions agreement when you start employment that automatically transfers everything to your employer. And then also afterwards, if your employer is pursuing a patent, you're obligated through that original inventions agreement to sign the form that needs to go to the patent office. So the reason a lot of companies have those things for patents is because it's not true. This fact is not true for patents. And then what ends up happening is companies just decided, okay, well, I'm going to put copyrights in that agreement also, just in case. So you don't have to have it in an employment agreement for copyright, but lots of companies do. So it wouldn't be unusual to have that type of agreement for your employees. For startups, this often comes up with independent contractors also. So if you hire an independent contractor, like you hire a company to build an app for you or to build your website, or you hire someone to do a photo shoot for you or to do video for you, all of those people are creating tangible content that you need to make sure is transferred to you in writing. And the standard independent contractor agreement would say, basically, once you pay them, it belongs to you. You need to make sure that it says that it belongs to you. For photographers, it depends on the type of photography, but some like sort of professional, like fashion type of photographers will keep the copyright in stuff that they take, and they will only give the company that they're hired by like 2 years license. And then they'll say like they continue to own it, but they're not going to use it with anybody else. So it kind of depends on the leverage of the photographer, but in most kind of standard circumstances, you should pay them and you should own it. And that's what an independent contractor agreement should say. And if it does not say that, or if you just are like, oh, well, they just did it, my college roommate built my website for me, like you need to get it in writing. And we do a lot of those after the fact. And we do a lot of those after the fact when a startup is trying to either get investment or when they're trying to sell their company, because it can be very problematic if you find out that you don't actually own the thing that you think that you own, and it's like crucial to your company and your branding and your identity as a company. So address ownership in every contract. That's really the key takeaway for copyrights. Once you are the owner, you have the right to reproduce, that's make copies, distribute copies, display, perform, that doesn't always apply, and create derivative works. So derivative works are like if you write a screenplay, the movie is a derivative work of the screenplay. That's a pretty simple example of that. There's a lot of gray area around derivative works, but that's just a general overview. So copyright registration.
Hey, Parna, I have a quick question.
Yep.
About copyright. What if you use AI to create your logo or a product image? How does that work?
That's a super good question. So it depends, which is the lawyer's favorite answer. So it will depend on the first thing is the terms of the AI service that you use. So there's things like, I don't know if you all are familiar with Canva, for example. They have a provision in their terms of use that there's certain of their materials that if you use Canva to create a logo, you cannot file a trademark application for that logo. I mean, you could still do it, but you would be breaching the terms of your Canva agreement. So the scope of use that they're giving you is not the scope does not include trademark use or trademark filings. If you just use like ChatGPT or one of the other sort of off the sort of consumer sort of apps or products that are available, and you're continuing to do like a bunch of iterations of your instructions and it's changing and changing, you will still get something that's arguably unique. You would still need to do trademark searching for it because you would want to still make sure that it's not confusingly similar. You may still be able to get a trademark registration for it. The Copyright Office has, I haven't read, they have just issued a bunch of reports on AI, but the Copyright Office's basic position is if something was created by a computer, it is not copyrightable. So there has to be a human author for copyright. So there's a bunch of arguments that the human author is in the prompts, right? But the Copyright Office's current position is if there's no human author, it is not copyrightable. So you can still pursue trademark registration. You just would want to do your standard clearance searching, but you would not be able to assert copyright authorship or ownership. If you had like a there was something that was combination of AI created and non-AI created. Like I think one of the cases the Copyright Office looked at was like basically like a graphic novel where the artwork was AI created, but the text was created by the author. You could submit that for copyright registration and you exclude the images as created by AI, but you can protect the portion of it that was created by a human. So it is a that's the current state of things. It will likely change. I don't know. I don't think the Copyright Office will change their position. I don't know if the Trademark Office will take a position on AI generated logos. I doubt it because, you know, there's always been, you know, computer use of computers to create graphics, and you can protect those as trademarks. You just want to do your standard searching for those.
Great, thank you.
Okay, no other questions, Riley?
No.
Okay, super. So registration for copyright. Copyright exists upon creation. I always think it's a fun fact that copyright and patent rights are in the Constitution, so they are constitutional rights, which is just an interesting fact about our laws. So copyright registration is not required, but copyright registration is required if you want to file a lawsuit for copyright infringement. So copyright exists upon creation, and then if you want to file an application for registration, it gives you additional rights, similar to the trademark process. It's more crucial for enforcement because you don't need a registration to enforce your trademark, but for copyright, if you want to file a lawsuit, you do have to have a registration. You also can get attorney's fees and what are called statutory damages, but only if you had your copyright registered before the infringement started. It's possible that you find out about infringement and then you're like, oh, I really want to go after that person. So you file your copyright application at that stage, and then you file the lawsuit, which is you can do, but you're not entitled to the same types of an amount of damages if you do that. And copyright is an alternative to trademark protection if you want to protect like your label designs, like the whole, the entire, like if you have a product label and you want to protect the whole thing, copyright's an alternative to that. Copyright registration it lasts like, once you have a registration, it's like, it's either, I think it's either 90 years or the life of the author plus 70 years. So it's a really long-term protection. You create an account with the Copyright Office. I think it's $65 to file a copyright application. The downside is that it's work by work. So if you have like, if your business is creating designs that you're going to put on products, each of those designs has a separate copyright application. If you have a number of different like written materials that you want to protect, each of those has to be submitted in a separate copyright application. The only exceptions to that are photographs, which if you're a photographer, you can do like a group of works at the same time under one filing fee. And there's a few other exceptions, like for unpublished works, you can do 10 at a time together. So it can be very affordable. It can also be expensive depending on the type of what your business is. But it is, I would say, relatively inexpensive for a pretty significant benefit from registration. You get significantly more damages available to you. It sort of gives you muscle if you have a copyright infringement situation. So for like the most important materials in your business, there's very little downside to filing a copyright registration in most instances. Okay, trade secrets. So any other questions on copyright before I move on? Okay, super. So trade secrets can be really anything that is proprietary and confidential to your business that's not generally known. So business information, financial information, technical information, customer lists, vendor lists, ingredient suppliers, essentially anything that gives you a competitive edge over over other companies. A trade secret is created by the actions you take to keep it secret. So you have to keep something secret through reasonable efforts. And again, the value comes from it not being generally known. There's no registration process. It's just what you do to keep it secret. And first, you would have to prove that you have a trade secret. And the way that you do that is by proving how you kept it secret. So things like non-disclosure agreements. Everything is password protected. If you have hard copies, they're in locked files. Even internally, there's limits on like only the executive team can see this, or only people who work in the factory, or things like that, right? Like only a need to know basis. Like those trade secrets are shared with people only on a need to know basis. And that is the last slide. So trade secrets, essentially, there's a federal trade secret law and there's a state trade secret law in every state. And essentially, in order to pursue someone for a trade secret violation, you would pursue them under that law, under those laws. A lot of trade secret protection happens in employment agreements, right? Employees are required to keep things secret. And then through non-disclosure agreements is the main way. And then if you have any sort of vendor agreements or any sort of agreements with any third party, there's generally a confidentiality paragraph in most business agreements that says you might get confidential information in the course of this relationship and you are required to keep it secret. If there are things that are very valuable, like recipes or whatever that are very unique to your business. Another best practice is just to have like a footer or a header or a watermark on a document that marks it as confidential. So there can be no question in anybody's mind that those materials are confidential. And all of that will help you if you need to prove that it's a trade secret. This is a really broad overview, and there's a lot of specifics that will apply in one industry or another industry, and best practices and things like that. So I'm happy to, I know it's only 9:30, I'm happy to open it up to questions if others have questions, or if you have something that's a question that you don't want to ask in front of the whole group, you can always reach out to me separately, or to Riley, and Riley can connect you to me as well. That's my contact information and my glamour shot. I'm just going to
feel free to unmute if you have any questions.
I'm going to stop sharing for one, and we can see better there. I just want to make sure there's nothing that we missed in the chats.
Can you put your contact information back up on the screen for a second?
Oh yeah, absolutely.
Thanks.
I'll also be sharing this video with everybody, and I'll include Parna on the email so you can all connect with her directly.
I have a question about product packaging and the shape. How long does a product shape have to be in use before you can trademark that?
That's a super good question. So when you're doing a trademark application for a shape, or when you're just trying to establish that you have rights in the shape, the phrase that's used in the law is acquired distinctiveness, and there isn't any like absolute answer, but generally it's at least 5 years, and you need to have like substantially sort of exclusive use, and you need to be able to demonstrate a lot of marketing and sales and consumer recognition. So the types of advertising that really help with product packaging is like, look for the such and such bottle, or, you know, the type of like, directing consumers to associate that shape with your brand, can be very helpful, in establishing the trademark. If you have, that's where like making sure you have exclusivity with your packaging vendor is helpful, because if there's a whole bunch of other companies that are using the same packaging, it's going to be much more difficult to get trademark rights in that shape of packaging, if it's a shape that you're trying to protect.
Okay, thank you.
Yeah. More record keeping and particularly advertising that focuses on the uniqueness of it is what's going to be the most helpful in that situation. All right, I'm going to take down this contact info, if that's okay. Other questions? All right. Well, I'm really glad that everyone could join us this morning. Hopefully there was something that's new to you or that was helpful for you. And I'm very happy to chat with anybody after this. And I would say if there's other topics that are of particular interest to you that are in the IP space, let Riley know. And we'd love to put something together that focuses on specifics that folks are interested in.
Excellent.
Great. Well,
Well,
yes,
thanks
thanks
so
a lot.
much,
This was
Parna.
really useful. Appreciate the information.
Yeah, absolutely.
Thank you, everybody, for joining us today. This has been recorded, and so we'll edit it up and we'll send it out to folks a little later today or tomorrow morning, so that you have a copy of it you can look at in the future. And it will include Parna's information for how to connect with her on LinkedIn or email her directly. We'll have other Business Essentials programs in September and October, so look for those online. But thanks so much for being a part of it today, and reach out if anyone at OEN can help support your business as you grow. Enjoy the heat. Be safe in the heat, everyone.
Thanks. Have a good day, everybody.
All right. Take care.
Bye, everyone. Thanks, Riley.
Thanks, Parna.